The following video is for educational purposes only, based on publicly available information. It is not legal advice, and all opinions expressed are our own. Viewer discretion is advised. Hello, and welcome back to Employment Case Files, the channel where we break down real employment law decisions and uncover practical HR lessons that every organization should know. Today, we're diving into an insightful case from the Court of Appeal. Introduction: Chege versus Timsales Limited, a dispute that teaches us so much about disciplinary procedures, resignations, and the fine print surrounding retirement. Grab your notebook, because this one has some powerful HR takeaways. The storyline: Peter Njuguna Chege had been working for Timsales Limited since 1997. That's over 2 decades of service. In 2018, the company delayed salaries, tensions rose, and employees became restless. On July 25, 2018, Timsales locked out workers, alleging participation in an unprotected strike and absconding duty. The union stepped in and filed a case, but the court dismissed it and allowed the employer to carry on with disciplinary proceedings. So on July 1, 2019, Timsales issued show cause letters to Chege and other employees, and this is where things take an interesting turn. Instead of responding to the disciplinary process, Chege claimed he had retired, effective the day before, June 30, 2019. He said he tried delivering the letter, but was blocked by the watchman. He then took it to the labor officer, posted it through his advocates, and even emailed it. Talk about covering all bases. Timsales denied ever receiving a valid retirement notice. They also pointed out that Chege had not been working since July 2018, more than a year. Chege filed a new case, arguing the disciplinary process against him was illegal. The trial court dismissed his claim. He appealed, and that's how we ended up with this 2025 Court of Appeal decision. Key facts about the case. Now let's look at the main arguments. From Chege's point of view, his retirement was both valid and unilateral. He believed that once he issued the retirement notice, the employer had no authority to discipline him because, in his understanding, the employment relationship had already come to an end. On this basis, he argued that he remained fully entitled to all associated benefits, including gratuity, leave pay, and even constitutional damages for what he viewed as unfair treatment following his attempted retirement. Timsales' position was that the purported retirement was invalid and merely an attempt to evade the ongoing disciplinary proceedings. According to the employer, no proper retirement notice was ever delivered, and in any event, Chege had already absented himself from work since July 2018, long before he attempted to retire. The judgment. So what did the Court of Appeal decide? Here's the headline: Chege's appeal was dismissed in its entirety. The court made several critical findings. First, that retirement is not valid without proper notice. Second, that an employee cannot use retirement as a tool to escape an ongoing disciplinary process. Third, that the employer was fully within its rights to proceed with disciplinary action. And finally, that no employment benefits were payable. In the end, Chege was also ordered to pay the costs. Analysis and key insights. Now let's talk about what HR professionals, business owners, and organizations can learn from this case. Lesson 1. Notice must be proper. Retirement or resignation is not valid just because the employee says so. It becomes valid when the employer receives proper notice in the right manner. Lesson 2. You can't retire to escape discipline. The court made it crystal clear: disciplinary actions don't magically disappear because an employee tries to resign or retire. Lesson 3. Documentation wins cases. Timsales won because they meticulously documented everything, including absences, warning letters, show cause letters, and all disciplinary steps. Lesson 4. Manage staff unrest. Carefully, salary delays contribute to conflict. HR must communicate early and transparently to prevent escalation. Lesson 5. Understand the CBA. The CBA did not allow unilateral retirement. Both employers and employees must understand their collective agreements. As an HR leader, remember these key takeaways. Resignations and retirements must follow proper procedure. Employees cannot bypass the process to escape accountability. Courts will always consider the timeline and intention behind actions, and fairness and compliance matter for both sides. Conclusion. What a case. Chege versus Timsales teaches us that retirement isn't a magic exit button when trouble starts brewing. It reinforces the importance of following due process, keeping documentation tight, and ensuring clarity in communication. This is exactly why we do employment case files. Real cases, real decisions, real lessons. Drop a comment below. Do you think the retirement attempt was genuine or strategic? And let us know which other employment-related cases you'd like us to explore next. Don't forget to like, subscribe, and hit the notification bell for more HR insights and employment law breakdowns.